Division of property. Basic legal information presented by Community Legal Education Association. This is general information only, not specific advice. For legal advice on your specific situation, talk to a lawyer. The Family Property Act sets out rules for dividing family property between married spouses or common law spouses. For married spouses, assets include property acquired while married and living together. Assets include property acquired while common law spouses have lived together. Also, property acquired in contemplation of marriage or a common law relationship is included. Foreign property is included, and generally all family property is equally shareable. The law is different for common law spouses who have separated before June 30th, 2004. The date of separation is important for determining share of property and value. The following assets are not shareable: the value of property acquired before the marriage or common law relationship, but any increase or decrease in the value of the property must be shared. Property excluded by a prenuptial or cohabitation agreement. Personal injury award to compensate one partner only. A gift or inheritance given to one partner for only his or her benefit and kept separate from other family assets. And property acquired after separation. Jointly owned property is not included because it is already owned equally. An accounting is a list of each spouse or common law partner's assets and debts. It shows a list of the assets and debts at the date of separation. In Manitoba, you don't divide the actual assets. You equalize the value by making an equalization payment. Based on the accounting, it is possible to decide how much the spouse or common law partner with more assets should pay to the other to equalize their positions. For example, if Tanya has $40,000 in assets and Sam has $20,000 in assets, Tanya will have to pay Sam $10,000, so they each end up with $30,000. If the parties cannot work out an agreement about property, each would file their list with the court, and then the other party can respond to it. The court may grant an unequal division if satisfied an equal division would be grossly unfair. This is rare and requires extraordinary circumstances. Examples that might be considered include: one spouse came into the marriage with a disproportionate amount of assets. One spouse accumulated a significant amount of debt during the relationship, for example, as a result of a gambling addiction, and the other spouse was not aware. The value of any asset is the amount you would receive for that asset if sold in the open market by a willing seller to a willing buyer. In an accounting, the date for including assets and liabilities and the valuation date is the date agreed to by the spouses or common law partners. If they cannot agree, it is either the date they last lived together, or, if they are still living together, the date either makes an application to court for an accounting. Family assets can be valued by agreement, appraisers, business valuators, book values of vehicles, or auctioneers. Private pensions are a very complicated area. Pension credits which build during the marriage or common law relationship can be shared. People can also waive their rights to each other's pensions, but this must be done in writing and with independent legal advice. Parties also have the right to divide Canada Pension Plan benefits upon marriage breakdown, but Manitoba does not allow you to release your pension rights for CPP. The family home is most often a couple's largest asset. One spouse may ask for the right to live in the former family home without the other spouse. This is known as exclusive occupancy. This is possible even if the other spouse is the owner of the home. Partition and sale versus postponement of sale. Parties may have competing interests in the home. One party may wish for the home to be sold, while the other party may ask the court to postpone the sale of the home. If a home is owned by one of the spouses or common law partners, the non-owning spouses still have homestead rights. That is, the right to live in the home for their lifetime. The non-owning partner must consent to the home being sold before it can be sold. The non-owning spouse must also consent to any mortgage or pledging of the home before these things can be done. Sometimes, after a separation, spouses or common law partners may delay dealing with the division of family property. For example, when parties want to get a divorce quickly so they can remarry, they may choose to wait before asking for an order for division of family property. This is called severing the divorce from the other matters. The family property division may then be dealt with at a later date. The parties can also apply to the court for an interim equalization payment, or for an order to preserve property so that one spouse will not dispose of or give away property for less than it is worth. After a separation of common law partners or the divorce of married spouses, there are specific time limits for applying for a division of property. Under the Family Property Act, the rules are different for pensions. After a divorce, the time limit is 60 days from the day a decree absolute of divorce is granted, or 60 days from the day on which the divorce takes effect. The court may extend the limitation period by such length of time as it considers appropriate. You would have to show that you did not know that the divorce had taken effect, or that you did not know the date of the divorce, or that there were circumstances beyond your control. The time limits for common law partners are either 60 days or 3 years. 60 days from the date a dissolution is registered with Vital Statistics, if you register your relationship with Vital Statistics. The time limit is 3 years from the date you started living apart, if you did not register your relationship with Vital Statistics. The court may extend the limitation period by such length of time as it considers appropriate. You would have to show that you did not know that the dissolution was registered, or that you did not know the date of the dissolution was registered, or that there were circumstances beyond your control. Division of family property in Manitoba is mainly governed by the common law and the following provincial and federal laws: the Family Property Act, the Law of Property Act, the Married Women's Property Act, the Common Law Partners Property and Related Amendments, the Real Property Act, the Pension Benefits Act, and the Canada Pension Plan Act.